My name is Kyle Basinger, and I'm a partner at Goranson, Bain, Ausley. Today, we're discussing family law with family business owners. There are unique issues with family business owners that are going through a divorce. One of the obvious problems is with valuation issues and how someone's interests will be purchased. But there are other issues as well that are going to be quite challenging. And one of the issues that I frequently see is that with corporations, the ownership interests are not always stated. Sometimes the owner interest will say it's jointly owned, sometimes it'll say it's 50%, or many times the exact percentages are not even listed. This can create quite a few problems when parties are going through divorce as far as who has the authority to do what action in the corporation. An additional problem is if one party has a 50% ownership, it can be quite costly for that particular party to be bought out. But in addition, there are other issues. Sometimes a spouse will provide a vital role within the company, so that if that one spouse leaves the company, it can increase the cost of running the business because you have to find a replacement for that spouse, or there can also be loss in the value of the company because of the role that that spouse provides. In addition, the relinquishing spouse will have the issue of how does that spouse replace the income that you're losing from the family business. There are a number of options that are available that people are probably aware of most of them. There's obviously the litigation option where you can go to a judge and ask a judge how to divide up the family business. Another option is you can go to mediation, and both parties will have attorneys, and you'll try to reach an agreement through mediation. But a process I'd like to especially focus on today is the process of collaborative law. In collaborative law, it is an interest-based approach where both parties determine what their interests are. So instead of taking positions, they decide what their interests are, and together, through collaboratively trained attorneys, will come up with an interest that works for a solution that will work for both of them. There are unique issues with the family business, and the court will only see you for a very limited amount of time, but through collaborative law, you can craft a solution with the people that know the business the best. And both parties can decide what their interests are, what they want to take out of the business, how's the best way for a person to be compensated from the business. And by using collaborative law, through a methodical process of collaboration, a mutually agreeable solution can be reached by both parties. I have an example of how that might work. I had clients that owned a import-export business. The wife ran the manufacturing side and the husband ran the sales side. Neither party could do without the other. The wife had all the contacts in the manufacturing realm, and the husband did most of his business overseas with his sales contacts. The business would suffer a huge loss if either sold, partly because neither party had the resources to buy out the other one, but in addition, their contacts and the role they played were unique. And so through collaboration, they came up with a very innovative solution. And the solutions they came up with was they formed two subsidiary companies. One company that was going to be manufacturing, the other company that was primarily going to be sales. Each party could run their company the way they thought was best to run it, and they wouldn't step on the toes of their former spouse. But then they kept the original company open, and that became the parent company. Both spouses owned 49% of the parent company, and they had a trusted employee that had been in the business for years, and that employee then had a 2% interest that was granted to him, and he would be the tiebreaker in case there ever was an issue at the parent company. That was a solution that never could have been obtained in litigation, but instead through collaboration, the solution was decided by the parties, and 10 years later, it is still working. If the parties had gone to court, the solution would have been very different. More than likely, the court would have either ordered the business sold. If it sold, it would have been a huge loss for both the parties, as well as their loss of income. The other option is the court could have come up with a business that probably would have been valued in multi-millions, and neither party had those types of funds to be able to buy out, and it would have saddled the company with debt for years and years to come. Whereas with the solution we came up with, with, the company remained profitable, both parties maintained their living, their source of income, and the company was not saddled with the debt that would have come through litigation. Some of the best advice I can give parties that are looking at going through a divorce and their family business owners are, first, take a look at your documents and find out exactly how the ownership interest is stated in your ownership documents. My other piece of advice is to seriously consider doing collaborative law, because the solutions you can craft up would be much better than a solution that a court will give you.